Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you for joining us. Again, this is Saul Gruber from Gruber Trial Consulting, your host on the Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. And today, this was a real fun interview. Jody Moore from Johnson Moore is just a phenomenal both trial lawyer and nursing home lawyer who I've known for many, many years. She and her partner, Greg Johnson, are two of the smartest people I've ever dealt with out in California. And Jody I should say hit, but Jody got a $13.5 million verdict for 10 clients who were injured at a particular nursing home with one of the big claims was corporate malfeasance and understaffing. And she did that with a few other lawyers in the area who she'll talk about. And what I loved about this interview with Jody is because we're both kind of high-end nursing home lawyers, for lack of a better word, we were really able to delve into some fascinating things that will help anybody who's ever handled a nursing home case who wants to handle a nursing home case. Plus, she'll talk about her amazing verdict. So this is really one of those can't miss. And I hope you enjoy it. And here is Jody Moore. And again, this is Saul Gruber from Gruber Trial Consulting with my very special guest, Jody Moore, on the Jury Thinks What. Hi, Jody. How you doing?
I'm great, Saul. Good to see you. Thanks for having me.
You too. It's been a while since we've seen each other. And I kind of think the last time we saw each other, I think was in New Jersey. It's been that long.
Wow, that has been a long time.
Because I've missed a few of the nursing home seminars. I'll be in Seattle. If you're listening to this, Seattle's probably already happened. You're going to be in Seattle?
I'll be there too. Yeah.
So
I'm talking on the nursing home panel.
Oh, I knew that. All right. So we will definitely have at least a cocktail, perhaps dinner while we're out there. But that's great. But Jody, you were here, well, because you and your partner are two of the smartest people I know. And since I think I know everybody, that's pretty good. And I know you had a verdict which made us all snap our heads back. I mean, we knew you were on trial for forever and a day in California. It seemed like it. Yes. And you get a $13.5 million verdict in what I think is the craziest state I've ever seen for elder care, because between the caps and then the elder care statute, it's incredibly confusing. But I am so glad we finally were able to get you on this podcast since a lot of our subscribers are nursing home lawyers. So thank you for coming.
Thank you for having me. Yeah, I'm excited to be here.
How is your partner, Mr. Johnson? Is he doing well?
He's doing well. Yes, we're both in the sort of summer crazies with high school age kids, and so he's traveling and getting ready to send one off to college. But yeah, we're all good. We're doing well at Johnson.
Excellent. So you are, I know you guys out in California call yourself elder abuse lawyers because of the statute, I guess. Yes. Back east, we call ourselves nursing home lawyers. But whatever it is, you're certainly one of the leader of the packs. Can you just share with us a little bit about your background and how you got into elder abuse law?
Sure. So I've been practicing in this field for, healthcare my entire career. So I graduated law school in 97. I got one of those jobs that you just sort of get because you know somebody who knows somebody. So I ended up in a medical malpractice defense firm. And it was a great job, actually. It was a good job. It had good training. I really got exposed to healthcare litigation through that. But I commuted and I was in LA and I didn't really want to do that. So I got a job kind of more local to Ventura County. That job was nursing home defense work. I know. The secret comes out. I actually worked with Tom Beach. Anybody in California will know who that is. So I worked with him. I made it about a year. My grandmother got sick.
Ooh.
And she was hospitalized, and she ended up having a stroke and was sent to a nursing home. And I thought, okay, this nursing home in my backyard. I know all the things to do and ask. I did the tour. I grilled the administrator, the DON. I stuck my business card over the bed. We visited in shifts. I mean, we did all the things that you're supposed to do. And she ended up with a bed sore the size of a dinner plate that they didn't tell us about, right? Until it was really bad. And so I'm still here. Okay. And they didn't tell us about it until it was really bad. And I figured that out. And we did the whole thing, push the call light, nobody comes, walk up and down the hallways and try to find a nurse, and they're having a party in the break room. Like, I saw all the stories that I had been told were all exaggerations or unrealistic expectations. And unfortunately, she passed away in that nursing home, and I inherited $500. And I opened a bank account under the name of the law offices of Jody Moore, and the rest is history. I switched to plaintiff's work. Yeah.
Good for you. And I know if they're defense, and I'm sure they're defense lawyers listening to this, they're probably all rolling their eyes, but yeah, good for you.
Well, it's all true. Every word of it's true, and every case is sort of in the name of Grandma Ruth. And I was not even a 3-year lawyer at the time. So there was actually quite a bit of looking back naivete or hubris or whatever you want to call it. But I had a very supportive husband who had a stable job. And he said, if you're ever going to do it now. And so I did.
Well, that's wonderful. That's really wonderful. So this podcast, and we'll put this on there, is for Grandma Ruth.
Yeah, thank you.
Absolutely. It's so funny how many people have that similar type story who we both know. I mean, I know David Hoey has almost the exact same story. Mm-hmm. And I'm sure I'll get a text from him when he listens to this saying you talked about me again, but that's okay. So now you're handling nursing home cases, and there's this, you probably get this phone call all the time from somebody who says, I've seen some of the settlements or verdicts you guys get. I think I want to do nursing home cases. Is it hard? I hear it's easier than medical malpractice. What do you say to those lawyers?
Yeah, no. Yes, it's hard. No, it's not easier than malpractice. Here's an anecdote. So, my business partner, and he's kind of a jokester. He's got a wonderful sense of humor. And I call myself the world's worst car accident attorney because I don't know how to do a simple case. I don't know what is negligence? What is duty breach? I don't know what to do with it because there aren't all the bodies to uncover. You aren't looking for the lie. You're not analyzing reams and reams of data. You're not learning some new aspect of medicine that you had never learned before. You don't have 27, clinical experts, right? And so the truth is, and particularly, well, I only know California law, but you mentioned California law is really complex, and it is. We have a pretty high burden in order to sustain an elder abuse verdict. You have to prove malice, oppression, or fraud, and clear and convincing evidence, and corporate malfeasance. All of those additional hurdles make these cases really complex. And if you don't know the law sort of forwards and backwards, and the defense firm does, they'll run circles around you because the judges are not terribly familiar with the law because the cases aren't as common as a general PI case. And it's not just healthcare negligence where you prove the breach and you get your damages. You have to prove all the additional stuff to get there. And then once you do, you still are subject to the cap.
Exactly.
So yeah, it's not for the faint of heart.
It's funny. I can remember probably 10, 15 years ago, I was taking a deposition. We had many offices in New Jersey, and I was in the South Jersey office. And somebody from the North Jersey office said, look, I've got a case down there. I know you guys don't handle auto. You only handle the malpractice in the nursing home. It's a dep of a driver. Can you cover it? It's in the same building we were in. I'm like, yeah, I'm free all day. They said, just send me the police report. I don't think I need anything else. 2 hours later, I'm finishing that deposition. And I get a call from the partner. Said, yeah, I just talked to the defense attorney. They begged me never to have you cover a simple driver deposition ever again. Said, why were you asking all those questions about, you knew what the law was, you read the DMV, but yet you still chose to break it. I'm like, I don't know how else to do it.
Isn't that how a depo is supposed to
Yeah.
go?
I thought we're supposed to find every single thing there is. He goes, no, it was a simple red light, green light case. I said, oh, okay. And that was the last time anybody in my old office ever said, can you cover this non-complicated case?
Yeah.
But I think people forget that all of our depositions, when you think about it, every single one is an expert dep.
Yeah, it is, because you're trying to establish, well, what are the rules? Where are those rules codified, right? We can talk about the regs and the policies and
Sure.
various, clinical journals. So what are the rules? Everybody knows them. Did you follow them here? What would it look like if you followed them? 'Cause
Right.
that can be ubiquitous. Well, what does following this turning and repositioning look like? Do you have a sheet? Is it electronic? Whatever that is.
Mhm.
What can happen if you don't follow the rules? You might as well ask that and figure out if they're going to tell you bad things can happen, right? Well,
Always
we know
ask that.
reposition, we're going to get bed sores or whatever. And then why didn't you do it in this case? I might not frame it as a why, but that's the hit, right? Why did this person not get the care that you knew that they needed in order to have their wholeness and their wellness covered?
I mean, that is what we do. That is the nursing home case.
Yeah.
But, one of the things that we were talking about earlier before we actually started to record was some of the issues that were involved in the case that you were able to get such a great verdict on. And you had said to me that there were two big things. One was understaffing, both subjective and objective, as well as I forget what the other one was.
Corporate control.
That's it. Corporate control, corporate malfeasance, which, is just a bunch of amorphous words normally by lawyers who've never done it. They say, well, it's profit over people. It's this, it's that. I'm like, yeah, okay. But you really have to get into it. I really want to talk to you about those two things because I think they're so complicated.
They were complicated. Well, in a lot of ways, the staffing was less complicated than the corporate control in this case. So can I take a step back and just give you a little overview?
Yeah, I was about to ask you to do that. Perfect.
Yeah, let me just give a little overview because this was a really unusual case. So, and my involvement in it was unusual. So I'll give you the 2-cent version here. So a colleague of mine in the Bay Area, Susan Kane Gordon, started getting a couple of calls against this particular nursing facility. She recognized that there was going to be a handful of plaintiffs that she was going to try to bring in a joint action. And she brought in another firm, Jennifer Fiore. So they're Bay Area firms, and they worked up this case. Ultimately, they had 16 plaintiffs. 6 of them split off into arbitration, and 10 of them were in the Superior Court. And they were scheduled for trial. The case was being worked up when the pandemic hit, is what really happened. They needed
so this case was the discovery was going on right when the pandemic hit.
Correct.
Wow.
And they had filed a preference motion because we had elderly living clients, and the preference motion couldn't even get heard because the court was shut down because of the pandemic. So the preference motion got heard and granted. I don't remember if it was exactly December of 2020 or January 2021, but there was basically 120 days to work up 10 plaintiff cases. The trial was originally scheduled to begin in May.
Did you say 20 days?
120 days in California. Yeah. Once you got the preference granted, it's 120. It's 120. It was still a race, believe me. This is 10 plaintiffs. So 120 days to get the case prepared for trial, had a May trial date. I got a call from one of the attorneys from Susan because she was making an inquiry about one of the experts in the case, one of the defense experts. And I answered her questions, and we started talking about the case. And that kind of turned into, hey, do you feel like trying this case with us? Would you want to come in and bring your elder abuse litigation background into the case? And Susan definitely knows what she's doing with nursing home cases, but hadn't tried one to verdict. She has a nursing home practice, and she did all the workup, and she did it all extremely well. And Jennifer Fiore, as well, as an experienced trial attorney and had taken cluster cases to trial and done corporate liability cases.
Wow.
But again, didn't have the specific nuance of like being able to rattle off all the nursing home cases in the last 20 years.
So that's a pretty powerful team that was put together for this.
Yeah. And it wasn't lost on me that it was a team of powerful women, attorneys, business owners, and I wanted to be a part of that. They also had a pretty powerful book of experts that are very well known for supporting, not supporting, but for working in the nursing home field. And
but I know the experts you had. They're just not well known for working nursing home cases. They're well known for working on only good well, I shouldn't say good, but horrific nursing home cases that there's really not much of an issue as to the viability of them.
Right, right. So it's power team of attorneys, power team of experts, power group of cases going to trial on Zoom during a pandemic. Of course I said yes. So I'm like, sure, why not? Let's do it. So I say that tongue in cheek. It was a big commitment, and it was an honor to be asked to work on it. So I said yes and got involved about 6 weeks before the case went to trial.
Wow.
As I mentioned, there were 10 plaintiffs. We had to do it on Zoom, and we had a pretty limited schedule. I think we originally had 12 weeks maybe, and the jurors were on half days, so 9 to 1:30 Monday through Thursday.
Because they were normally home.
They were all at home logging in on their devices,
Oh my Lord.
in their kitchens, in their offices. One person was in their garage. I mean, you could just really kind of get a sneak peek of the whole thing. So that in and of itself was really incredible. And kind of set the stage for the case. I'll pivot to, go ahead.
Here's my question for you though, and it just confuses me, and I apologize for that. When you're talking about clusters, so you're actually trying in front of the same jury a case that involved 10 different people with different injuries.
Correct.
So what type of injuries were involved?
Say that again, it cut out.
What type of injuries were involved?
Oh yeah. So that was the other thing that, every injury that comes up in our nursing home cases was in this case. We had repeat falls and fractures. We had bed sore management, mismanagement to gangrene and amputation. We had malnutrition and dehydration, kidney failure. We had several unexplained bruises. We had a sexual assault case in the mix in there, which
you really did have the whole list.
We have, if it, failure to recognize and manage infection, failure to send to the hospital. We obviously had poor documentation and poor communication. We had lack of care planning. So we had sort of those systemic issues as well. And that's all sort of the underpinning of plus understaffing and corporate control. So it was all the things in one case.
Wow. So it's my 25 years of doing nursing home work all in a case.
Yeah, that's how I felt about it.
So
Definitely.
how did you make the decision to do a cluster as opposed to bring 10 different cases?
Well, that decision was made before I got involved, but I think it was in part, I can tell you this, it stayed a cluster because there was a challenge to that, right? It stayed a cluster because of the common issues of law and fact. And the common issues in law and fact were, we have this pervasive pattern of understaffing that impacted the delivery of care to all 10 residents. And we shouldn't have to put that on 10 times. And the corporate control issue was going to be the same. We shouldn't have to put that on 10 times. It also happened to be during the pandemic, and there happened to not be 10 courtrooms available. So what impact that had, I don't know, but that's what the context in which this was occurring. Plus we had preference. So we just couldn't get the cases reasonably tried without the consolidation.
Yeah, especially with the preference. I would think the preference is really big there.
Yeah. And we had a really exceptional judge. And I say exceptional, not because he ruled in our favor on everything, because believe me, there were things he did that I didn't agree with, but he was attentive and he was trying really hard to strike the right balance of trying this case in a way that gave us access to the courtroom and let us tell this story, but not prejudicing the defense. So for example, he phased the case. So he did certain things in phases. He did the corporate control part of the case in some respects as a phase one, because we in California, we have a statute that says in order to be responsible for elder abuse, you have to have the care or custody or substantial caretaking and custodial responsibility for the person. And so what happened was, we have the first layer of care or custody as the licensee, and nobody disputes that. Yes, the licensee has a duty of care and they have custody and so forth. But the next layer up is, the management company, and the management company is providing their care and services by contract. And they say, well, we're just the third party. We administer payroll. We don't have anything to do with the delivery of care. Nobody's ever handed anyone a glass of water. Nobody's ever come in from this company and done any turning and repositioning. Like we just don't do care. And therefore we're not responsible under the California version of the law. And so that part of the case got bifurcated, if you will, and became phase one, is does the management company, I'm using that term loosely, that's their term, does the management company, have care or custody of the residents of this building?
Well, that's interesting. So, and then you would have above that, I assume the corporation that owns the management company, or is it all in one under the guise of management company?
We didn't get to the next level up, again, for procedural reasons that are
Okay.
probably beyond the scope of our podcast. So we
Right.
only had the licensee and the next layer up management company.
Let me stop you and let's talk about that, because that's something that everybody who handles nursing home cases struggles with every day of the week. So now you have the management company and you have the licensee. What I see often is they're the same owners, or different LLCs, but the same owners. Did you have that issue as well?
Yeah, I mean, again, we had like underlying layers of entities, right? So like this entity is owned by this entity and this entity. And so that now we have to deconstruct these entities. And so on some level, we had to say, how much complexity is this jury going to be able to tolerate? Right.
Mm-hmm.
And so we had a kind of an easier path, I would say. What we had we had common officers and directors and managers. And we had people who were officers and directors of the management company who were sitting on the governing body of the licensee. So, right, the governing body by statute is responsible for the day-to-day operations. So if you have two people who are high-ranking officials in the management company who are actually sitting on the governing body, there's an argument to be made and an inference to be drawn, which our jury drew, that says, okay, yeah, this management company is not just some back office payroll.
Right.
They're actually responsible for the delivery.
And for those of you out there listening to this and you're trying to follow, governing body is a key phrase that you need to use in your discovery. Not officers, but it's governing body, because it's specifically referenced in the regulations, in the administration regulations, the 0.75, one of them after 0.75, I think. And you need to find out who is on the governing body, both in written discovery. And I personally have always asked the administrator and anybody who's involved in management that same question, and also ask them about the governing body. And if they get confused, you just show them the regulation to unconfuse them. So that's interesting.
What's funny is, maybe 40% of the time, the administrator has no idea what the governing body is, right?
They really don't.
So you have to ask for it in discovery too, right? Because then the corporation has to answer. But the law is pretty clear that you have to have one. And so.
Yeah, they are the people that are allegedly hire the administrator and make all the decisions in the nursing home. So now let's set the stage. Okay, so you've got your licensee, you've got your management company, and you've got the management company and the licensee share people that are on the governing body.
Right.
How do you now put something together that you're going to show corporate malfeasance? What do you do? How do you go about doing that?
Well, one of the things that the management company is responsible for doing is setting and enforcing all of the policies and procedures. So again, if we're back to what are the system breakdowns in terms of the care planning, communication, documentation, bringing in specialists, transferring to the hospital, all of that, it's all done according to the policies and procedures. And the policies and procedures are drafted, implemented, and approved by the governing body and the management company. In this case, the management company contract even said we furnish the policies and procedures to the licensee. So that's one hook. We had a hook regarding the management of resources, right? So who's actually writing the checks? Where does the money go? Who's responsible for the budgeting? Who's setting, who has to approve each and every expenditure, beyond something that might be petty cash or something like that. Well, that's all flowing through the management company. And then finally, the people. So we had a people, policies, and profits kind of trifecta, if you will. So, and then the people were also controlled in terms of hiring, firing, training, oversight, supervision. So it sounds simple kind of when I say it like this, because I am simplifying it. But it was complex because, they don't want to admit it. They, of course, one of the things that happened in phase one was they came in and they said, we're just a consultant.
Right.
Every person who took the stand, everybody was pretty much a corporate rep under 776. So everyone who took the stand was like, we're just a consultant. we provide administrative services pursuant to a contract. And it was so clearly planned, right? Because that's the
Sure.
same words came out of everybody's mouth. But the truth was, just a consultant doesn't, make rounds, which was something that they were doing. We actually used one of our experts. We used Christopher Cherney as our nursing home administration expert, to kind of talk about, well, this is what a true consultant looks like. A true consultant can't log into the computer system, offsite 24 hours a day, for example. So we had a lot of examples of what distinguishes a consultant from someone who's actually doing the operations and hiding behind the name consultant. And ultimately, the jury agreed with us that that's what was going on.
So when doing that in discovery, obviously you want to ask the questions of everybody. Who do you report to? Who do you use to assist? How often are they there? Do you send emails? Do you communicate? It's incredible. It's incredible. These consultants have access to the 24-hour census report 24 hours a day. And don't even get me started with how much access they have to the MDS and how that should be completed. Do you think in order to truly address those issues, you need an administrator for trial?
Well, that's a good question. I think that I'll give a shout out again to Susan and Jen. I think they did such an incredible job in the depositions of all of the officers and directors about, going through methodically, what is your role in relation to policy and supervision and training and money and budgeting and,
Right.
discipline and all of it. And so can you get there without an expert? Yeah, I think you can. Does it help to have an expert summarize and bring forward and add context? That's what our experts do, right? They add context. And so I don't think I would want to do it without an administrative expert. I don't think I would want to do it without someone who explains why the structure is set up in this complicated way, why there's so much resistance to calling themselves responsible when they clearly are. Those are some things that we can only do when we have the consultant.
So they're doing all this work in the depositions, asking all these questions about corporate malfeasance, about money, and about care. These are really long depositions.
Yes. Yes. And actually, California has a 7-hour deposition rule. But you probably can do these in 7 hours. Some of them are person's most knowledgeable or 36 style. Some of them are just literally, you're the vice president of operations. We're going to talk about operations as long as it takes for us to get all these questions answered.
Yeah. I mean, I agree. I think the devil's in the details. I don't think you get to stand up and say profits over people unless you spend 20 hours deposing people to actually get the facts to show that.
Right. And some of what, I'm talking about in terms of corporate control wasn't even a profits over. We weren't even getting there. We were just in the, do they control phase. We weren't even like, and did they do it wrong phase. We were just in the, how do you prove that this entity is really calling the shots? And I will put another plug, if you will, for really setting the contracts. I mean, I know we can talk about generically licensees have contracts with managers and they say X, Y, and Z, but there is variance among different contracts and they change as lawsuits like this come forward and they get caught in a certain we're going to change that line again in our contract. And so you do have to deconstruct your contract, sort of line by line. Well, what does it mean when you have the authority to do whatever is deemed reasonably appropriate to meet the day-to-day requirements of the needs of the residents, right? That's like some catch-all phrase that ends up being super important to the jury, because if I'm doing anything reasonably appropriate to meet the needs, that sounds like they're in my care and custody, right? It sounds like I'm directing how the care is going to be delivered.
It's funny that you say that, because I've had this discussion with attorney clients of mine where they're very upset when they get all these contracts with the money has been redacted, the fee. I'm like, you know what? We can deal with it. We could deal with the fee later. If you get those contracts, let's look at the contracts. Yeah. And it's incredible, some of the older cases. And I can remember when I was still handling the cases, some of those management company contracts were incredible. We are in charge of everything. We'll hire people, we'll fire people. We could fire the administrator if we want. You're like, wow, that seems controlling to me.
Yeah, exactly. So there were a lot of, nuggets that we could pull out of the contract as
Absolutely.
well. And then you use that contract as the basis for your questioning in the depositions to just nail it down.
One of the things we used to see a lot, at least in New Jersey, and maybe it was earlier in the day before Debbie Goffey, Dave Cohen started to handle all these cases, was they literally would be signed by the president of the nursing home and the president of the management company, who were like always the same people.
Yeah. This like, oh, who manages you? Like who there's this concept of self-dealing, right? Like, well, this was an arm's length transaction in order to negotiate the most fair terms with this totally independent third party, but the same person signs on both lines. I mean, I consider that a gift, right? Because I think the jury
An
can
absolute
see through
gift.
it. So go ahead and tell this jury that you're completely divorced, you're completely independent. One of the questions I like to ask is, of the if they're different signers, let's say the administrator signs, or somebody who's a different signer on behalf of the licensee signs, and then the management company has a different signer. The question to the administrator or whoever signs is, well, are you free to go contract with anybody else providing services, right? Because they're captive, right? The only management company that can provide management services within that brand, that family name, that's not a chain, it's just a brand. We're just a, for marketing purposes on our website, is that company. Like, you can't, be an Ensign affiliated facility and go out and contract with life care centers for administrative services.
And their answer is always the same: is, well, why would I want to?
Right.
They're so great. Why would I want to? But the jury sees through that in about a second.
And that's another nugget, right? There's some really great stuff on the website and their own marketing materials. And I know we know to go get that, but I can read a website 10 times and find something new or nuanced when I look at it. And
I can tell you, I tell everybody, and we always did, one of the first thing we did was go to Medicare.gov and download that when somebody called about a case. The second thing we did was just preserve the webpage on Adobe. It's certainly not hard. You literally take the link, put it in Adobe Web, and it saves it as a PDF.
Yeah. And it's branded, again, it's branded with the management company logo and their color scheme and the pretty pictures. And then it says right there, we provide 24-hour care. And you're like, but you don't have care or custody, right? It's like, your website says you do. We provide skilled nursing services. We provide look at all the care we provide, but we don't provide any care. We're just that's just the branding.
And don't forget, find everybody's mission statement too. I know we're just running around here, but it's really true. Because those mission statements can be beautiful. Now, how many depositions are you taking in a case like this, which is obviously significant because there's 10 people, but how many deps were taken in that case where the verdict was rendered?
I believe there were, and I could be misquoting this, I think in our fee petition, we had 74 depositions, but I'm also remembering 111. We also took a bunch of depositions between liability and punitive damages.
Right.
So 80 to 100 is my best estimate.
Okay. Now, as I catch my breath, how many other cases do you have where you did 80 to 100 depositions?
For me, that doesn't happen.
Okay,
right?
just checking.
No. In my sort of day-to-day practice, if you will. But if you think about it, okay, I've got 10. If I have 10 plaintiffs, am I taking 80 depots across 10 plaintiffs? Yes, I am. Absolutely.
Sure.
So now there was consolidation, obviously, of experts. We only had one or two. Sometimes the defense had two experts and they split them, 2 plaintiffs each, or 5 plaintiffs each expert. But we did still have to take, the nurse who took care of Mr. Jones and his wound relating to his amputation, right? We still had to take those specific depositions. And so that's part of why it burgeoned the way that it did. So,
oh, no, I could see the 80 to 100, because when you think about it, you're taking, the only thing that's joined is the corporate stuff. All the injuries, there's going to be different. You're going to take different depths in a fall case than you are in a dehydration case, right? So, okay, I just wanted to make sure.
Yeah, but like the DON, the administrator, the MDS coordinator, like all of those folks, they only got deposed once. Now, it might have gone over several days because we took breaks and so forth, but we didn't take independent, administrator depots, 10 independent depots, because we had 10 plaintiffs.
So before we get to the next topic, I'm going to put you on the spot, because that's what I do. So you've got a case in your office. It's a pressure ulcer case, and it's a nasty wound case. How many deps do you think you would take in an average in a case like that?
Oh, that's really hard to answer. That's
I'm
like
going to ask a different question. Actually, who do you absolutely, in your mind, have to take in those cases?
I have to take the wound care nurse, whoever prepared the care plan, the administrator, the DON. Those are no brainers.
Right.
Whether I go up or down or sideways from there really depends on where I am in the case, right? But my initial discovery plan is going to be anybody who knows anything about the wound, and I might do like wound on admission, wound when, skin on admission, wound when it was first documented, and wound on discharge, for example. So there's going to be that kind of thing as well.
Now, will you try to do that? Will you try to do that in some cases just through the DON, or will you always have 3 depositions? Normally it's probably one person doing all 3, but
yeah, my experience is that there's a wound care nurse. There's going to be a wound care nurse or charge nurse that's going to be the one actually documenting the condition of the wound, and that's different than the DON. And I start low and go high, right? I want to start lower on the totem pole and work my way up so that I've got my rules and my facts and my understanding of what this record actually says and means, and the policy according to their own records. I want to have all that first before I go and talk to the DON and the administrator, typically.
Right. I kind of agree with that. There's so many different ways to do it. That's why I love to hear what you have to say. I have always saved the DON for last, just because I felt that the DON I could clean up anything with the DON that happened in any of the other depositions. Right. So, and I always like to start with the administrator first.
Yeah, I've done it that way. I've certainly done it that way. And there's a benefit to that, again, because you can start establishing all of the rules according to the regulations and the policy. And I do like that, and showing kind of who's at the top of the food chain and getting the org chart and all of that. So definitely have done it that way. Sometimes out of our control in terms of scheduling.
Yeah, most times it's out of our control, the scheduling.
We have a wish list of how we want to do. And I know there will be people listening who will be like, screw that. Of course, it's going to be in the order in which I say it's going to go, right? But sometimes we're just really practical. Like, this one's going to happen a week before that one.
Yeah,
listen, it to happen. So they go forward that way.
I mean, if each lawyer is handling between 15 and 20 cases, well, that's what I say it should be. I mean, I know there's a variant depending on who you speak with, and you have 5 lawyers, and between all of you, you've got 120 cases. Sometimes you're just going to take whoever the defendant can put up at that time because you're thrilled to death to get a deposition. Yeah. What about the MDS coordinator? I mean, I always used to say it was important. The way things have changed lately, I'm not so sure how important it is anymore. What's your thoughts on that?
I kind of put my depots in tiers, right? Like, the first tiers are the must-haves. The second tier is like, if we get there, and then the third tier is like, I'm not sure I need them depending on the facts, or I know I need them, but let's wait till we get closer to trial. So the MDS is usually kind of in that second cluster, if you will. And it depends on whether I think I have MDS fraud. It depends on whether or not I've got, like, let's say I've got some handwritten record that says this wound was present on admission, and I've got MDS coding that says there's no wound on admission, right?
You mean like 70% of your cases?
Yeah, exactly. So yeah, under those circumstances, then I'd be more likely to take it. So but I don't just automatically take it in every case.
Before the changes were made over the last 4 to 5 years, and we were pretty much rug oriented and therapy oriented, would you take the MDS in every case?
Yeah, I was more interested. I was more interested in the rug scores and what does that mean in terms of the minutes of care and all of that. Yeah.
I'm just curious because we did the same thing. Once the PBJs came out, the payroll-based journals came out, it kind of eliminated that sex appeal of the MDS coordinator, for lack of a better word.
Yeah.
Now, so you're armed with all that information that we were talking about earlier with the corporate control. You've got all these great nuggets in your dep, and you're hit with the motion for summary judgment to let those people out. How do you respond to that?
There wasn't a motion for summary judgment to let the management company out. There was just this, there was an initial challenge to bringing all the cases together. And then there was there go back to with preference in 120 days, there really wasn't time. But now
Right.
they had a year prior. If they wanted to bring an MSJ, they could have. But they did not bring an MSJ on that issue. So essentially the first phase, that care custody phase, was like, a mini trial on that issue. And if we were going to succeed or fail putting on that evidence in phase one.
Now, the other big issue, I don't know why I keep having this brain cramp, other than the control and custody. What was the second part?
Staffing. I was going to say we didn't talk about staffing.
I'm so sorry about that.
That's okay. I would have brought you back there.
I want to address the staffing, because that is a particular, I want to say pet peeve of mine, but it's not really a pet peeve, but it's an issue that I struggle with in every case that I've ever handled and have ever consulted on.
Yeah.
How do you go about analyzing staffing and what to do with it?
Well, I mean, we start with the statute, right? We have an objective standard and we have a subjective standard. In California, the objective standard is codified. So it was 3.2 nursing hours per patient per day up until a certain point in time. And then it went up to 3.5 nursing hours per patient per day with a minimum of 2.4 for hours. And so we can objectively, measure against that standard. But again, that standard is a minimum. So it doesn't mean that it meets the actual criteria, which is the federal criteria, which is, you have to have enough staff to meet the needs of everyone.
So whoever's listening, so we've got normally the state level, which will give us a minimum number, which the federal level doesn't give any number. And of course that's a minimum. Then we look to the federal regulation, which says you have to meet the needs of the residents.
Right.
Now, when you say it's a 3.5 PPD, hours per patient day, what do you then look at to determine what was actually being done in the facility? What documents do you need to make that determination?
Oh, you're going to test all of my memory here, but
either in this case or in any case.
Yeah, no, we had like 8 categories of documents, right? Because you have their self-reporting. So in California, they post it on the wall, they self-report. This is, per day, per shift, this is how much we did. Obviously, then you have staffing schedules. Well, who actually was scheduled for the month? Let's just say ambitiously, we're looking at the whole month, who was on that schedule. Then you have a daily schedule. Who came in that day? Who signed on the daily schedule? And then you have a room assignment. Okay, they signed on this daily schedule. Now what room, what hall, what person were they assigned to, or special assignment? Then you have payroll, right? You have your time reports, your time records. And then sometimes the payrolls run more than once. So you got to get every iteration of the timekeeping record.
Okay.
And then in California, there were some additional, there's a 530 form and a 612 form, which goes back to the assignment sheets. And so you're sort of cross-referencing all of it. You're cross-reference, and then you might have a budget or a staffing ladder, which we had in this case. So we're looking prospectively, here's how much staff we think we're going to need per the budget and per the schedule. And then we're looking at who actually showed up and signed in, but that's handwritten. And then we're looking at who actually got paid. And you cross-pollinate all of that and you figure out, is it reliable and is it accurate?
Who says this isn't easy? Who said this is difficult?
Yeah, I'll give a shout out on that one to Christopher Cherney. I mean, he was one of our experts and he did the staffing analysis in this case, and he meticulously went through all of those records. Oh, I left out one, which was really important in this case. We had time card correction forms in our, which is, if the time card's not working or someone forgets a punch, they can submit a handwritten document that says, I forgot to punch in and out for lunch, dock me or whatever, or I left and I was in a hurry and I didn't punch in or punch out. And it gets signed off by the employee and signed off by the administrator. And now somebody manually keys into the payroll record, whatever the accurate timing is for that day. We had thousands of time card correction forms in this case. And they're all signed by a single person at the facility. They're not countersigned by the employee. They all have time in, time out, set, like everybody's time card correction form says 7:30 exactly. Like missed punches are not always going to be exactly on the half hour.
Of course.
And so we also analyzed the time card correction forms. And so with all of that evidence being brought together, we were able to show that they were not accurate in their self-reporting, and that they were actually falling below the objective standard.
Wait a minute. You're telling me the nursing home who has an obligation to self-report was not accurate in their self-reporting?
I know it's shocking to hear, Saul.
Wow.
I hate to be the one to break it to you,
Wow.
but no, it was not.
Do you use at all the cost reports in trying to determine understaffing?
We do use the cost reports because they have payroll-based hours, right? So
Right.
state cost reports and the federal cost reports all have payroll-based hours, and the PBJ data as well has payroll-based hours. And so those items also get triangulated into the mix. I guess I think about looking at those as trying to, once we look at the staffing records and we figure out, well, something's not right here, then we go on to the OSHPOD and the PBJ to determine if we can prove a pattern of fraud.
Okay.
Kind of sort of distinguishing understaffing from fraud, if you will, in terms of the analysis, but they're obviously related.
And one of the things that we always did before everything became so really good and technical is one of the simple things we used to do when we just got the case, even before we filed suit, is just take a look at the payroll-based hours in the cost report, and then look at compare that to the days, the days that were actually the amount of days that's in the cost report, and try to come up with at least a working HPPD before getting all that information. Do you still do that, or do you don't do that anymore?
We ballpark it, yeah, in the beginning of the case. We do ballpark it, but it's did I say it was complicated? It's complicated, right? Because the PBJ data exists from this point to this point, but
Right.
then after that point, we lose the quarter. And so when was my time period? And so there, if all the things line up, then yes, we do that analysis. If we're missing a quarter or whatever, then we come at it a different way.
Did you find in this case that we're talking about the Chris Cherney's testimony and the objective findings of how understaffed they were compelling for the jury?
Very compelling for the jury. So I actually got to do his direct examination, which was one of the highlights of the trial for me. And so we were able to prove both subjective and objective understaffing in his testimony. We did understaffing with the every witness, obviously,
Right.
DN administrator and our nursing and physician expert as well. But Christopher really laid the groundwork for it. And so he had all these tables and spreadsheets.
Yes.
That's what he does. And we were able to actually introduce some of the tables under the rules of evidence that allow you to do a summary of voluminous information. And so that ended up being really helpful because the jury could see the table, they could see the outcome. And based on his analysis, we had this facility below the objective minimum requirement on 328 days in a 3-year period.
First of all, that's an immense amount of work to prove that.
Yes, it was.
For any of my clients that are listening, it is an immense amount of work, both hours and costs to do that type of, and you can only do that in certain cases, but and that's why you got one of the reasons you got a $13.5 million verdict, because it's so compelling.
Yeah. Yes. And then I'll tell you what he also did. So that's the objective, right? Because what we hear is, well, you've got this, daily staffing number. And so everybody's supposed to get this minimum 3.5 hours a day. And even if we were below the 3.5, Mr. Jones could have gotten 4.0 and Miss Sally over here got 2.0. And so you can't connect this understaffing on this global facility-wide level actually impacted your client. So that's phase 2, right? Phase 2 is, okay, Christopher, show me where understaffing impacted care. And he was able to do that again through, meticulous review of the records. And, so we would have, for example, shower and hygiene tables that showed, in the month of December, somebody got 3 showers. And that was also a month where skin breakdown progressed significantly. And so we're like, okay, if you don't have enough people, then you can't do the showers per the schedule. 3 showers is not adequate, right? You got to have at least 2 showers a week. Even that, jurors turn their noses at that. Why, who's not getting showered at least every other day? And the correlation between lack of adequate hygiene and bed sore progression, right? And so we had table after table after table. We would show, for example, in our fall cases that the care plan included increased supervision and monitoring, maybe Q1 hour checks. Maybe we had a one-on-one sitter recommended in one of the cases. But we see that there's no implementation of that degree of monitoring and supervision. and the person falls 17 times in a short
How
period.
did you determine whether there was that type of supervision or assistance? What documents within the chart were you able to review, or was Chris able to review to make that determination, if you know?
Well, so from the very specific, for example, this person should have a one-on-one sitter. Obviously, that was never ordered. It was never
Right.
arranged, and there's no indication that was ever done. Down to, the degree of monitoring and supervision, we would just say, your care plan says this person should be monitored, every hour. Where's that log? Doesn't
Right.
exist. If it's just increased monitoring and supervision, you would just ask the caregivers, did Mr. Jones get any additional supervision that Miss Smith down the hall didn't get? Because the truth is, when you say, call light within reach and increase monitoring, that's the same level of care that everybody in the building gets, regardless of their individualized care plan that's supposed to be associated with their risk profile. So if Mr. Jones is getting the same thing that everybody in the building is getting, then it's obviously not an individualized care plan. So
I don't know why people don't realize that more. I say to everybody, I used to do this in every case and every trial. I'd have the care plan blown up, and I would say, this is specific to this resident, correct? Yeah. Follow doctor orders on care. Can you explain to the jury when you don't follow the doctor's orders? It's just, give ointment if ordered.
Yeah.
I don't even know what that means. And
Yeah.
I love those.
Yeah.
And the other one is, make sure call bell is within reach.
Yeah.
I haven't figured out yet when a call bell shouldn't be in reach.
It's true.
Yeah.
It's true.
Water I get, right? Water, sometimes you're not supposed to have water. I understand that part, and I would just go through, and you'll take a care plan that may have 12 pre-printed interventions. 9 of them they don't even need to be in a care plan.
Right.
Yeah.
Right. Because it's the standard.
Ask the resident how he's doing.
Yeah.
Okay.
Yeah. Encourage, fluids, encourage activity. You're like, oh, great, thanks.
Yeah.
Okay.
And my favorite, then we'll jump back in, was encourage turning and repositioning to the person who has a BIM score of 2 and has end-stage dementia.
Right.
I used to compare that to telling your 2-month-old, stop crying.
Yeah. Yeah.
What's wrong with you? Stop crying.
Yeah. Yeah.
So if you're listening to this, Jody and I are telling you, please look at the care plan very closely.
Yeah.
And discriminate and figure out what is really an intervention and what is just a bunch of BS.
Right.
So you're armed with understaffing, at least the where you're looking at the chart and showing it. Do you have to pair that with the stories of the families?
Yes.
Tell me about that.
Well, the stories again kind of provide context. I mean, I think trials are about storytelling, right, at their base, and we can talk about storytelling in voir dire and opening, but every witness exam is its own story, and so the families come in and give kind of the color commentary. They're the ones who come in and say, I was there at the bedside, assuming this is not during COVID. In our case, predated COVID. I was there, I was at the bedside, I was calling for a nurse, no one would come, or I walked in the room and they were covered in their own urine and it smelled and I couldn't get anyone to change their diapers, right? Those are the anecdotal stories,
right,
of understaffing. We had a really compelling case in our story by one of our clients who came in and talked about walking in on his mom, and she had a dirty diaper and she's just, covered in her own feces. And he didn't say it that way. I mean, his mom's covered in shit, right? And it's like, my mom deserves to not. It was like going up her back. It was in her hair. And he was begging someone, literally beg. He's like, I was like this big, strong African-American man, like begging to get his mom cleaned. And it was one of the most compelling, aspects of testimony. And I can't perform that for the jury. I can talk about, it's a fundamental right to have shower and hygiene and its relationship to dignity cannot be understated. I can say that all day long. Or this man can come in and say it hurt his heart to see his mom covered in shit. And then he had to literally beg to get her cleaned. And that was enough.
So really, you talked about storytelling. Let's shift a little into that because I don't want to keep you for the whole morning.
I know we could talk for a long time.
Well, yeah. I mean, that's one of the problems when we bring other nursing home lawyers on this podcast. That, it's just like having dinner at a convention. We'll just talk about this stuff forever. Yeah. It's great, like you just said, to stand up and show charts, but you're not doing anything until you touch the juror's heart. Until you say to the juror, look, you got to stop this. Only you, wherever state you're in, 6, 8, 12, can say, no, that's not going to happen on our watch. Right. Tell me how you start the process of storytelling. How does Jody Moore start that process?
Well, gosh, where is the beginning? I probably start that process the first time I talk to the client, right? I mean, we can sit here and talk about case selection and what does it mean to have a quote unquote good client. But for the most part, if I'm taking a case to trial, I'm bonded to my client and their story and their relationship. And so it kind of starts by, another way of putting it is like, I think about what is my fuel when I go to trial.
Right.
And if my fuel is to make money, for example, that's not very good fuel. It's fine. It's good. I make a living. It's good to make a living, but that is not the fuel that sustains me working, 15-hour days during trial.
Right.
And is my fuel like, oh, I really want the win. I need the win. I want the status that comes with the win. Also, it feels good. Love to have it. Not the best fuel, because what if you don't? And you and I can talk about sometimes you don't. Right? I sound like Dr. Seuss, but we go into trial wanting and needing and feeling like the win is the only option. And I personally have had a bit of a paradigm shift on that my job is to go into trial and to fight and to tell the best advocacy story that I can, and to do it with love as the fuel, and the outcome will take care of itself. And that doesn't mean that I will win with the capital W every case. It means that I will show up and I will don the battle armor and I will tell the story in a way that serves my client.
I mean, if we're trying these cases, right, we're all going to lose. Any trial lawyer who tells you they don't lose cases, they're just not trying enough cases. It's just that simple. And I think, I spoke to Kentucky KJA about 8 months ago about mental health and wellness. And some of the things that drove me into some dark places was when you go to trial with these people who you've lived with for 2 years, 3 years, 4 years, it's a loss is absolutely devastating to us. Forget about the clients more often than not take it better than we do. At least in a nursing home setting, because it's the child, it's the spouse, but they got their day in court, they're okay. We're not sleeping for a month. We're well, I would never kick my dog, but what you said is really true. We've got to get to the point where it doesn't tear us apart, the loss. We can be upset by it, but we've got to understand how to deal with it.
Yeah. So I'll put a shout out here. So at the beginning of the pandemic, I found myself in the Lean Into the Pause, which is the hostage to hero, Sari Delamotte kind of community that she's built. And I needed to be there. We're in the middle of this pandemic, everything's shut down. It's like, future's uncertain, what's going to happen? And I kind of found that transformation through working with that group and with that community. And so I do believe that it's really important that we get our mind right while we're working on our cases, in our day-to-day lives. And then obviously that we need to get our mind right when we go into trial. And if we're going into trial with like winning is the only option and losing will be devastated, then losing will be devastated.
Yes.
Devastating, right? It's sort of a self-fulfilling prophecy. But I think that we can go into trial and think, I'm the best advocate for this case, this story, this client in this field of law on this day, in this moment in time. And I'm going to do the very best I can. And my best is pretty damn good. And I'm going to trust the judge and I'm going to trust the jury to see what's right and to do the right thing. And that's such a healthier mindset. It allows me to get up in the morning and do the really hard work and tedious and long hours, because I feel like I'm standing on the right side of the principle and I'm doing something really important. But I'm also my critic of, you better do it perfectly, or if something goes wrong, you did something wrong.
Right.
That critic is really destructive. And we probably all have one, and you need to learn how to deal with it and put it in context, because it can take over and it's not healthy. So I'm glad you brought up mental health, because I think it's really important and we should be talking about it more, because otherwise that harshest critic, which is sort of our own inner voice, is going to can come in and take over. And
it does. And Jody, you know, this is the most nursing home lawyers, you know, I'm the victim of it. You know, I was chair of a lot of different things, and going from verdict to verdict and thinking it all had to do with me, that when something didn't go right, oh my God, what did I do? And you may have done absolutely not only nothing wrong, you may have been phenomenal. You may have been perfect. It just may be the jury wasn't in your corner that day. That happens. But you brought up Sari Delamont. I love Sari stuff. Sari and I have been going back and forth to get her on this podcast, which would be perfect for this podcast. And she was away, then I was away, and it'll happen, everybody, because I've talked to her about it. But not only is her book phenomenal, her podcast, it's like 15 minutes long, or is just so great to listen to. It's almost like you're in therapy listening to her podcast.
Yeah. Yeah. And that's by design, right? Sari figured out that she could teach all the trial skills in the world. Like, she's, you know, the attorney whisperer. Her forte, if you will, is really voir dire, and connecting with the jury. But, you know, her profile, her skill sets, you know, go beyond voir dire, obviously. But that's kind of her niche, right? Like, how to connect with the jury, but how to reframe your relationship to the jury. And what she figured out, like consult after consult after consult, was that she wasn't able to get her clients to make that connection because they were stuck in their own heads in this mindset of, what if I do it wrong? I need to do it like the greats. You know, just tell me the formula, instead of standing in their own power, standing in their own greatness, instead of accepting the fact that you're actually willing to go to trial and tell this story makes you an amazing fucking lawyer from day one, right? And embracing that, right?
Amen.
And she figured that out. And so instead of just sitting around saying, well, here's how to perfect your question in voir dire, which is something we do in H2H, right? Here's how to ask the right voir dire question. You got to step all the way back and be like, what are you coming from? What are you bringing? What baggage are you bringing with you when you stand in front of this jury? And how do you want to be? Like that, I love that question. She's one of the first people that asked me that. Like, how do you want to be when you're standing in front of that jury? Do you want to be a nervous wreck? Do you want your stomach, you know, churning? Do you want your hands shaking? Do you want to be afraid? Oh my gosh, what if I do something wrong? Do you want to be worried and anxious? Or do you want to stand in front of them and be like, I'm a fucking warrior and I'm telling this story and it's important. And I'm gonna convey, because of my commitment to my client and my case, I'm gonna convey the importance of why we're here, non-verbally and emotionally, because of that connection. But you cannot do that if you're actually standing there worried and anxious and fearful, like, what if I do something wrong?
There's no question about it. And her, I mean, not only the just your thought process and the mindset, but when Sari starts getting into the funnels, and it's just, it makes sense. Like when you listen to her, when you read her book, and I'm telling everybody to, I'll ask for 10% from Sari if anybody joins up. You already work with her, so I'll just ask for a piece. I'll probably clip this and email it to her. But her the way she figures out these funnels, and she says, when somebody raises their hand, you know, great, you have somebody raise their hand. Doesn't mean you have to go ask them about it. Doesn't mean you have to talk more. Now you've just got someone who raised their hand, and now there's other issues you're going to bring up from that. Again, we're probably, if you haven't read some of her stuff, don't know what we're talking about, but I absolutely, her book's on trial guides, and it's something that's phenomenal. I know I've taken so much of your time up. You're going to have to promise me to come back again to where we can talk about just nursing home stuff and how to do some of that. The one thing I do want to finish with you on is this. Okay, so I was in the original Reptile nursing home group, right? With Keenan and a bunch of people. Let's see, I've been with the David Ball nursing home group. I've been with, Keith Mitnick's stuff. Keith's been a guest, right? So we're looking at all these books, and they're phenomenal books and they're great books. And we're looking for the best way to do something. What's your best way of doing something, Jody? Would it be Keith's way? Whose way is your best way?
Yeah, I have all the ways as well. I'm going to send you a picture of my bookshelf. I've done it all. I've done Reptile, Rules of the Road. I've studied with Rick Friedman and David Ball and Keith Mitnick. And I think there are pearls of wisdom in all of it. And I don't like to think of it as there's one doctrinal way. There has to be a way that I can show up, like I said, standing in my power, owning my story, owning my relationship to this jury, owning my relationship to myself about like, have I done everything I need to do to come here and tell this story the best way that I can? And that's the best way. And these are all just tools. These are all just tools in my toolbox. And I happen to believe in some tools more than others. Some tools are better for certain cases than other cases, right? But ultimately, if I'm not in the right headspace and I'm not kind of owning my own way of doing things, my own instincts, I think that's this is what I'll say. I think when I was a 3-year lawyer, 4-year lawyer, 5-year lawyer, I was running on instinct and I was really successful and it was fantastic. And then my head got wrapped up in the, what about the next case? What if I don't? Is it big enough? What if I let the next one down? So then I got in my head and then it was just pressure. It was like, and then it was like, now I'm reading all the books and I'm applying all the formulas and I'm less on instinct and I'm less happy. My verdicts are still okay, right? But there was a whole period of that. And for me, kind of what the pause did and coming back to H2H and sort of coming back to myself and getting grounded in my own mindset brought me back to my instincts. So when I'm being me, kind of like I'm being me in this podcast right now, when I'm being vulnerable, when I'm telling you like the good and the bad, when I'm recognizing what my position is in relation to the world, and it's not all about me, and then I'm just sort of a vessel. This is just sort of part of what I'm doing as a service to my clients and to hold companies accountable for wrongdoing. I am so much happier and I'm so much more at peace, and I'm a better advocate. That's the trick, is figuring out how to use yourself as your tool. And so
you are, the best way for you is the Jody Moore way.
Correct. Yeah.
And that's what everybody should figure out for themselves. The best way for me is the Saul Gruber way.
Yeah.
Take everything, put it in a blender, figure out what you love and what really lets you be vulnerable and honest to the jury. And that's your way.
Yeah.
Jody Moore, thank you. Thank you for coming on and talking. I'm going to hold you to coming back where we're going to dissect some nursing home issues. Maybe we'll put a panel together of a couple other lawyers and we'll just have some fun with it. So okay. Jody Moore, Johnson Moore, badass trial lawyer, badass nursing home lawyer. Thank you a lot. I appreciate it.
Thank you, Saul.
Again, this is Saul Gruber from Gruber Trial Consulting, your host of The Jury Thinks What. That was, as I told you in the intro, was a phenomenal interview. Jody Moore from Johnson Moore really was able to articulate what we're looking at and how we're dealing with both corporate control as well as understaffing in a way that's pretty illuminating and tells you how hard it really is. And she makes it sound so easy. If you have any questions about these type of cases, I know Jody is more than happy to talk to you. You can contact her over at Johnson Moore in, I believe it's Sherman Oaks, California. And if you have an elder abuse case in California, she's one of the top people out there. Don't hesitate to reach out to her and maybe bring her into the case. But I think if you're like me, you really learned a lot about the talking points that we hear of how you really prove them. Again, thank you for joining The Jury Thinks What. We will see you next month with another fascinating interview. I am Saul Gruber from Gruber Trial Consulting. And remember, if you need any help, just give us a call.
That concludes another episode of The Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.